Okay, thank you. Before we move on, another point of order, Jonathan Crawford.
At the beginning of Tuesday's proceedings, the Honourable Member for Bishop Auckland claimed the reason the Council of Her Majesty's Circuit Judges were not giving evidence because they would not attend at a given time. And I'd like to correct the record, as I understand the factual position to be the Council of Her Majesty's Circuit Judges were invited but declined the invitation as they felt that it is for politicians to decide these things and not for them to comment. They also passed on their thanks for being invited to give oral evidence.
I think that should be recorded. Okay, we have, before we move on, we have two minor amendments, I believe. Minister, to move the first amendment to the programme resolution of 12th of July 2011, standing in his name.
Formally, Mr. Chairman.
Move formally. Amendment proposed as on the amendment paper. The question is that the amendment be made. Amendment proposed as on the paper provided. The question is that amendment be made. As many of that opinion say aye.
Aye.
The contrary, no. I think the ayes have it. The ayes have it. Minister, to move the second amendment to the programme resolution standing in his name.
Formally, Mr. Chairman.
Move formally. Amendment proposed as on the amendment paper. The question is the amendment be made. Amendment proposed on the paper provided. The question is the amendment be made. As many of that opinion say aye.
Aye. Aye.
On the contrary, no. I think the ayes have it. The ayes have it. We'll now move to hearing evidence from Rights of Women and the National Federation of Women's Institutes. For the record, could you please just introduce yourself to the committee?
My name is Emma Scott. I'm the Director of Rights of Women.
And I'm Ruth Bond, and I am the National Chair of the National Federation of Women's Institutes.
Okay, do we have any? Helen Gibbon.
Thank you very much. We're very pleased to be taking evidence from you this morning. This bill doesn't make any mention of women, but I think in various ways women will be affected, and I wondered whether you had any views on whether any of the effects on men and women would be different or disproportionate, or whether women would be disadvantaged in any way by proposals in the bill.
I think we're really clear that there is going to be a disproportionate effect on women. We know that women are we know that women make up a significantly greater proportion of those who are in receipt of civil legal aid, particularly around family law, which is and immigration law, which are the areas that we're particularly concerned about. We, as an organisation, provide legal advice to women, and we speak to women on our telephone helplines on a daily basis, and those women come to us not just with one particular issue resulting from relationship breakdown. They come to us wanting advice about child contact proceedings, financial relief proceedings, welfare benefits, debt, immigration law issues. There's a whole range of issues that women need advice on, and we are very, very concerned that removing legal aid for those issues will significantly disadvantage women. And particularly our concern is around domestic violence and the definition of domestic violence within the bill, and that's not going to allow all women who experience violence to have access to family law legal aid, and that's going to put women at risk.
I would certainly reiterate what Emma has said. As it says, we are a women's organisation, and hence we deal with women. And we have a vast raft of research which we did on this subject. And I think it does disproportionately shall we say, outlaw women, because they're the ones we have found from our research and from what our members tell us that need to go for legal aid because they are so often violated.
Could I, just turning to the sentencing parts of the bill, the government is exempting domestic violence cases from the new rules on bail. In other words, if a person is being accused of domestic violence, that is a reason for remanding them to custody. The definition that's used in that part of the bill is physical and mental violence. Are you content with that as a specific enough test? Have you thought about that part of the bill as well?
We haven't specifically looked at the sentencing provisions, but I think what we're really clear about as an organisation is that where legislation talks about domestic violence, there needs to be a unified definition of violence, and that in our view that should be the definition that's been adopted by the government in their cross-government strategy and action plan to tackle violence against women and girls. That's the ACPO definition of domestic violence, and which has been adopted by many other government departments, by the CPS, by the UK Border Agency. The Ministry of Justice itself has adopted it in a number of documents. So there needs to be uniformity in any definition of violence in any legislation. We are concerned that any provisions relating to bail adequately protect women. We know from the cases of Jane Clough and Claire Bernal that there are very significant risks when perpetrators are released on bail, fatal risks to women, and therefore any provisions relating to bail in these kind of cases need to be as strong as possible.
At the moment, women are more likely to be sentenced for serious crimes, for longer sentences for the same crimes as men. Would you support the insertion of a women's champion into the criminal justice system? It's one of the recommendations in Causton that the last government didn't get round to implementing.
Causton's not a particular issue that we've been looking at, so I probably wouldn't want to comment on that.
Okay.
I'm afraid that's the same for me.
Elizabeth Truss.
Thank you, Mr. Chairman. On the subject of legal aid in general, Britain has one of the highest legal aid bills per capita in the world. And one of the reasons for that is a lot of issues which would normally be dealt with in other countries through standard appeals procedures or through non-legal advice end up being dealt with by lawyers. And you mentioned the specific case of welfare. Isn't it the case that in order to get welfare claims properly dealt with, there are appeals procedures within the welfare system, and there are other sources of non-legal advice that women could go to, and in fact all that we're doing by involving lawyers is just ratcheting up costs, not actually benefiting the end recipients?
I have to say again that welfare benefits is not a particular area of our specialism, but in general, in terms of the costs of legal aid, what we would urge the government to do is look at the costs of not providing legal aid to women, the costs particularly of not providing legal aid to women who are affected by violence. We know
that's rather different from a case about welfare benefits, which is one of the areas you mentioned in your earlier answer.
As I say, that's not our particular focus of concern in relation to the bill. Our particular focus is vulnerable women who are affected by violence.
So you would support the removal of legal aid for dealing with welfare benefits?
No, absolutely not, because as I said at the beginning, there are a myriad of issues that women face when they face relationship breakdown, and that is one of them. Ensuring that women have access to advice and support around welfare benefits, being able to challenge benefits decisions. I would say that there is a place for that legal advice. Yes.
Yes, I would say the same. I mean, we don't delve into all this in any great depth, but certainly we need to have other welfare things in there. The definition of how you can get legal aid is too narrow, and it needs to be widened, and this would be included.
Do you think our legal aid bill is too high in this country?
Again, as I started to talk about, I think that you need to have a look at the costs of not providing legal aid, particularly in the cases that we have concern in, which is domestic violence. We know from evidence that's been updated recently that the cost of domestic violence, where women aren't able to get support and advice and resolve issues and make safe arrangements for example, child contact, to be able to resolve financial and property disputes, to become independent of those relationships.
Domestic violence is within the scope, and the definition has been widened. The things that are being removed from the scope. I mean, it seems to me from what you're saying that we could almost allocate an infinite amount of money to legal aid, because there are no areas that you think the money shouldn't be spent on. If you're saying domestic violence is a priority, which I agree, and which we have widened the scope for, then let's make sure we spend the money on that. And indeed, those eligible for domestic violence legal aid will also be eligible for things like ancillary support through the divorce proceedings as well. So we're being more generous on that area and less generous on some of those other areas where it seems to me there's a rational reason to cut costs. I do think the case would be better put if you were to focus on the areas you thought really ought to be protected, rather than just saying we need legal aid for absolutely everything. I just wanted to make one more point on the whole issue of divorce proceedings, which is that we also have put forward proposals, or the government has put... Sorry.
Get to a question, because there are a number of people waiting to be...
Sorry. My question is, do you support the government's proposals for bringing forward cost support in cases where there isn't legal aid and there's an economic imbalance between the two parties?
Can I come back to the point of domestic violence, because I think it's misleading at best to say that there has been a concession on domestic violence in family law. What we say is that the proposals as they're set out don't adequately reflect women's experience of domestic violence and the way that they deal with domestic violence in their lives. They set out criteria that require women to have been through statutory routes to address the violence in their lives, to have had a criminal conviction, to have applied for a non-molestation order, to have been referred to a MARAC, and we know that simply isn't the experience of women affected by domestic violence. If I can just draw your attention to the Women's Aid annual survey last year, of the 17,500 women who had taken the very drastic step of leaving their homes to flee the violence that they've experienced. So these are women who unrefutably have been experiencing domestic violence. Only 10% of those had a criminal conviction for violence. Only 20% had applied for and obtained a non-molestation or an occupation order. And only 19% had been referred to a MARAC. Our own survey that we carried out in the run-up to our consultation response to these proposals showed that 53% of women responding hadn't reported the violence to the police, and they hadn't applied to the court for a protective injunction. So we are very clear that these proposals will not catch all of the women who are affected by domestic violence. We know those who are better experts than we in terms of domestic violence will say that women don't report, women don't disclose violence. I know from my own experience as a family lawyer that women very often don't talk about it until halfway through the proceedings, and therefore we can't assume that these proposals will ensure that all women affected by violence will have the protection of family law legal aid. And as I say, I think it's misleading to say that it does. We're also very concerned about the loss of legal aid in immigration cases where women are applying under the domestic violence rule, because those women are particularly vulnerable in terms of both their vulnerability to further violence, but also their ability to make their application for indefinite leave to remain.
No, brevity would be appreciated,
okay.
Not just in the questions but also in the answers. Are you finished?
Just one more point, and that this is on the letter from National Federation of Women's Institutes in response to the initial consultation, where you claim that the definition of domestic violence only included physical harm. And in fact, that was never the case. And indeed, the scope has been widened. Do you acknowledge that the scope has been widened?
Widened to include psychological. Yes, I acknowledge that, but it's still not wide enough. I mean, there's so many issues.
But do you agree it was wrong in the initial letter you wrote, and that it always included wider a wider definition of domestic violence than just physical harm?
I mean, from my recollection, the consultation paper did specifically refer to physical harm in a number of points, and that was where our confusion about that lay. It's clear that there has been a shift, but what's clear is that there isn't still uniformity in terms of the definition of domestic violence across this bill and across other government policy.
Okay, Kate Green.
Thank you very much indeed, Mr. Sheridan. I wanted to follow up a couple of the points that you've already alluded to. But more generally, first of all, I wonder if you could comment on the role that you see for mediation in relation to family cases.
Well, yes. I think in cases of domestic violence, mediation is never a good thing. In some cases of other issues, but certainly with domestic violence, no. It means that you have to face the perpetrator. It can be very stressful. And I think no, in all cases, no.
I think there's very, very clear evidence from not only the women that we speak to on a daily basis, but from other experts who've looked at this, that mediation is not appropriate in domestic violence cases. As Ruth said, it places victims at risk of further violence and abuse. It puts the perpetrator back in control in terms of being in contact with the victim. It can cause re-victimisation to the victim. And I mean, we know that women feel under a huge amount of pressure to seek agreement in family law cases. We know that they feel a huge amount of pressure to attend mediation and conciliation appointments, and that they feel pressured into reaching agreements that just simply aren't safe for them and their children, or in their children's interests. We know from the HMIC inspection report from 2005, there was a very clear recommendation about seeking mediated agreements in domestic violence cases, and they were very concerned that women felt that they were being put in dangerous situations by being forced to mediate. So absolutely, we oppose mediation in domestic violence cases.
But of course there will be legal aid available, albeit that we've talked about the definition for matters where domestic violence does exist. In your view, in cases where there's not actual violence, physical or mental, but there is very high levels of conflict, what's the appropriate role of mediation in those cases?
Well, violence is insidious, whether it's physical or otherwise, and I still say there is no.
Have you any views on the impact on the wider family, and in particular on children?
So views
on the impact on the wider family, and particularly on children?
Well, anything that will stop children being taken into care is the best, obviously. But no, I think. Sorry. Any way to save children from being put into care when it comes to dire cases, or even insidious cases that go on a long time. I think whether the courts intervene or not, we need to have a wider understanding.
Just, if I could ask Emma Scott, particularly on this issue about mediation's appropriateness in situations where there's no actual domestic violence, so legal aid will not be available for legal advice, but the woman, and indeed man, could be encouraged to go through mediation in circumstances where there are still very high levels of conflict. What's your view on that?
I think we are. I mean, we have been very concerned about the role of mediation and women feeling forced into situations where they don't feel that they have a level playing field in terms of negotiations and discussions. There are very clear and still pervasive imbalances between men and women within relationships, particularly around financial issues. Women we talk to very often have a very limited knowledge of particularly the financial arrangements of their marriage, and therefore there are still very clear inequalities, and there is a very real role for the courts to play in ensuring that fair and equal settlements are made in financial relief proceedings particularly.
And that leads me to the second point that I wanted to raise, following some of the remarks that were made a few moments ago, which is about the way in which problems arrive in clusters. And Elizabeth Truss made the point to you a few moments ago that there would still be the availability of legal aid for ancillary relief in divorce cases. To what extent are women who are presenting and seeking legal aid at present actually going through formal divorce, and to what degree might they be in informal relationships or separating? Do you have any information on that?
Before you answer, we have 6 members have indicated that they wish to speak. So, brevity, please, from the questions and the answers.
I'm not quite sure what you're referring to in terms of, are you talking about...
I'm asking about women who might not be getting divorced, therefore won't be in the ambit of the court. To what degree do you think these proposals meet their needs?
In terms of what kind
well,
of...
in terms of access to ancillary relief and legal aid for that.
If they're not going through divorce, they wouldn't be able to access ancillary relief proceedings.
Okay, Ben Wallace.
I know that.
Good morning. Serve under your chairmanship again. Could I just go back? Are you aware, because many people that respond to the consultation didn't pick this up, that should domestic violence be recognised, either mental or obviously physical, it not only would unlock all the other types of support, such as ancillary relief, contact, etc., to be funded by legal aid. Were you aware of that?
Sorry, if...
Should the court effectively recognise the objective test on domestic violence and legal aid then be granted, that would then unlock legal aid for all the other remits around it. It wouldn't just be dealt with perhaps on that specific injunction, that would be about everything else, contact.
Absolutely.
So you do recognise that?
Absolutely, but what we say is that the proposals are too narrow in the definition that they place on domestic violence, that they won't capture all of the women who are affected by domestic violence, because not all, as I said earlier, not all women will have seen their perpetrator convicted of a criminal offence, not all will have a non-molestation order, not all will have a child protection plan in place, not all will have been referred to a MARAC.
But I mean, do you not think that at some stage in the process there needs to be an objective assessment of domestic violence, that somebody has to make an assessment objectively about whether it has taken place? I mean, I would regard bullying, for example, as a mental, domestic violence, but somebody somewhere has to make an objective ruling about whether, so that it isn't just one word versus another, that people don't access it as a means to,
what we proposed in our response to the consultation, as well as, and I'm pleased to see that MARACs have been added to the list in terms of the gateways, we said that very often women will go to specialist domestic violence organisations or to social services or to their doctor, midwife, health visitor. So evidence from those kind of professionals, in addition to the kind of statutory routes that have been set out in the current proposals, would allow more women who are affected by domestic violence to be eligible for legal aid.
Okay. And secondly, on the mediation, I mean, of course, if domestic violence currently, and this is not due to change, currently if domestic violence is a factor, compulsory mediation or the requirement to seek it is excluded. So it isn't already, and is not going to change that. That no one's going to force people into mediation or force them to explore that as an option if domestic violence is a recognised factor in the process. That's what it is now, and that's what it's going to continue.
Absolutely. We have wider concerns about mediation beyond just their role within legal aid. In terms of the family proceedings rules, they're already been introduced in terms of participants in family proceedings having to take part in mediation information assessment meetings, and we've got real concerns about identification of domestic violence in those cases. I think there's been research that shows that 4 minutes has been spent addressing whether domestic violence is an issue in those cases, and it's really not adequate in terms of exploring the safety of mediation and the appropriateness of mediation. So we have wider concerns about the role of mediation in family cases.
Okay, in mediation cases that exist at the moment, of the 14,600 cases in 2009-10 where mediation was started, publicly funded, full or partial engagement was achieved in 70% of cases. That's where we got to. Of that, in 66% agreement was reached. I mean, it was a successful model for very, very many people. Mediation has worked at quite a high level in the last year, 9-10. And do you think it is wrong for the government to therefore say, well, to choose it as a favoured route? I mean, it seems to me a route that seems to have a very high success rate, seems to be going in the right direction.
But this has got the question right.
I mean, what we would say is that the women who contact us, who have been through the mediation process, don't always feel that that has been a successful process for them. They may have reached an agreement, but they have not always felt that they have been able to take an equal or safe part in that process.
And we have evidence from our research that a couple of cases, certainly with mediation, and seemed to be all right, but then it all went back or started up again. So it isn't always the answer.
You're going for vote?
Mr. Chairman. The government's own impact assessments say that about 79% of the current acts of assistance won't be eligible for family legal aid in future. So does 21% accurately reflect the amount of domestic violence in the UK, or the numbers of separations where there have been physical, emotional and financial, or any violence?
Well, first of all, I would say that I'm sure that not all cases of physical violence, domestic violence, are out in the public domain. I think that's the first thing. So whether or not that skews the numbers. And certainly from our research and our members who came forward, they said for a lot of the time, this is the first time I've ever mentioned it. And those who we had some who accessed legal aid and it was fine. Others who it didn't go fine. So I think we don't have to be skewed by numbers all the time.
I think it's very clear from the British Crime Survey statistics that there are many more women affected by domestic violence that are coming forward, and domestic violence remains hidden within relationships and within relationship breakdown.
I mean, you say that quite often, you said in your previous evidence, that they don't go to the statutory agencies. Quite often they go to other advice agencies. Do you feel there are enough of those at the present time?
Absolutely not. I think it's probably a separate issue in terms of the funding of women's organisations generally. We are the only organisation that provides legal advice to women. We're seeing a huge demand for the services that we offer as legal advice becomes scarcer and scarcer up and down the country. So and we know from our sister organisations that they are facing really challenging times, and women's organisations are closing. So there are fewer and fewer places for women to go. Particularly in terms of the proposals around the domestic violence rule cases, immigration rule cases. The government suggests that in the proposals that women can seek advice from other agencies. There just simply aren't going to be those agencies to provide that support, even if that was appropriate. And we would say that it's very clear from the law that it's a criminal offence to give immigration law advice if you're not regulated by the Office of the Immigration Services Commission or a solicitor or barrister or exempted, and therefore you're putting the proposals put advisors at risk of committing criminal offences if they are going to be supporting women applying under the domestic violence rule in that way.
I think we'll have to move on. Tom Brake.
I just want to pursue the issue of mediation. Restorative justice schemes have a very high satisfaction rate with victims, 95% in some cases, as I understand it, and that is really about mediation. And it often involves antisocial behaviour, harassment, bullying. I just want to understand why you are so categoric that in no cases of domestic violence is mediation ever appropriate.
I'm not sure I'm the best person to talk about the dynamics of abusive relationships. That's not my expertise, but it's very clear from my understanding of the power and control dynamics within abusive relationships that mediation does not provide a safe or a level playing field for negotiations and discussions to take place. And just from our experience of the women who contact us, they don't want to do it. I think when we surveyed women, again, in the run-up to our consultation response, an overwhelming majority of women and legal professionals told us that they did not feel that mediation was appropriate in domestic violence cases, and all of them talked about the dynamics of power and control within those relationships and how that could continue and be perpetuated through the mediation process.
And so often when a case does come forward and a woman has the courage to actually say, domestic violence that I've been suffering, mediation is way past then. They've usually got to the pitch where it's so bad they have to get out and they don't want to speak to their perpetrator. No.
I mean, women commented in our survey about feeling terrified to speak when they were face to face with their perpetrator, and I think it's very obvious when you've experienced perhaps years of violent and abusive behaviour that you would feel extremely unsafe.
I understand that, although I would have thought the same would have applied in terms of restorative justice schemes between victims and perpetrators. But I hear what you're saying. A different point. I think you made it very clear that neither of you believe that legal aid cuts are necessary. In fact, I think, Mrs. Bond, you suggested it should be extended. That's clearly not the government's view. But would you accept that in terms of what will be left within scope, such as domestic violence and harassment, that in fact the provisions are perhaps more friendly towards women rather than less friendly as a result of what is going to be left within scope?
We have no problem with looking at the legal aid bill and seeing how you can alter it, but it's a case, I think, of throwing the baby out with the bathwater at the moment. It does still need to go further, and yes, we've said women will be disproportionately affected by it.
I think have to move on. Andy Slaughter.
There's been a report published this morning. I least pictures have seen it, which is the Justice Select Committee's report on family legal aid. But the two or three headline issues that have been reported for that, I just wondered if you'd comment on. The first is the chair of that committee, Sir Alan Beath, said there'll be significantly more litigants in person following changes to legal aid. The courts are going to have to make adjustments to cope with more people representing themselves in what are often emotionally charged cases. Are those fears that you share?
Absolutely. I mean, we've seen more and more women having to represent themselves as legal aid has been restricted over the last 10 years even. We know from, again, our research with our service users that women will be deterred from taking legal proceedings which can provide safety for them and their children, and can ensure that they have financial settlements which ensure their independence and financial security, ensuring that they're not reliant upon the state. So we are very concerned about women having to represent themselves in proceedings, not least because these proceedings are incredibly complex. Ancillary relief proceedings are very very complex. I recently on our telephone helpline advised a woman who was representing herself in proceedings, and I could hear the fear that she had in terms of having to explain her situation to the court and tackle the Matrimonial Causes Act. Not only the complex legal issues that women are going to have to face in representing themselves, but also the potential that they're going to be facing their perpetrator directly in court proceedings, and again the re-victimisation that brings.
Yeah, well, that's my second point, and the Sun rather more prosaically covers the issue under the headline "Pedos to quiz victims in court," and quotes Mrs. Justice Porfley, who told the committee that a man accused of sexually abusing his stepchildren could quiz the alleged victims if he had no lawyer, and added it would be denial of justice and it would be emotionally the most upsetting of spectacles for any court to encounter. I mean, do you think there is a real fear of either having to go through the trauma of that sort of cross-examination, or simply not being prepared to go to court at all?
Yeah, absolutely. I mean, that's very clear.
Is it in order for Mr. Slaughter to not only partially quote to a witness without the witness having seen the details of either a report or indeed a report, secondly to omit the role of a judge in any court vis-à-vis the protection of a witness or a victim. A judge doesn't sit idly by and allow these things to happen. They have a duty to protect a victim and a witness.
I don't accept that's a point of order, and I'm certainly not in any legal position or any position to put forward a legal perspective, but what I would ask is for brevity and accuracy in all the questions, and particularly the answers, please.
I'm not sure how other than how the quoting is going to be other than accurate, and I object to the opposition's time wasting when we have very few moments left.
If I could say the same protections aren't available to victims in civil law cases. So in family law cases, you don't have the same kind of protection that you have in, for example, rape cases in the criminal cause, where witnesses can't be cross-examined directly by their perpetrator. And so these reforms, if they are put through, will increase the number of litigants in person and will increase the number of women who have to face their perpetrators directly in court, yes.
Okay, we only have a few minutes left. Ben Gilmer.
Thank you, Mr. Chairman. Some very quick questions. All I need is a yes and a no. Emma Scott, I'm sure you are well aware of jurisdictions around the world. Would you say that in Sweden they're probably at the forefront of the recognition and action on women's rights?
I have to say I'm not an expert in terms of the jurisdictions across the world. I wouldn't be able to comment on any other jurisdiction.
Do you know anything about the Swedish legal system?
No.
No. Generally, do you think? Okay, well, that was the no answer. You're right. It's a matter of great interest to me. I'm not. Let me put it to you on this then. In Sweden, in Germany, two countries which have led the way, I would say, in some progress in recognition and action on women's rights, I think we can agree on that, they have the highest rates of mediation in legal cases in the world. Is that something that we could learn from?
I without having explored it further, I couldn't comment.
Okay, second question. Do you accept that there are some vexatious claims based on allegations of domestic abuse and abuse of children in court?
No, I would absolutely refute that and ask where any evidence is of false allegations having been made.
Not one vexatious claim ever made in court on the basis of domestic.
I wouldn't be able to answer that. What I would say is where is the evidence
Third question,
that women will make false
allegations. Have you provided
allegations?
any alternatives to the government in terms of cuts to legal aid, which might be different in the impact on women?
No, but we fully support the Law Society's proposals around alternative.
And they were seen to be risible yesterday. So thank you very much.
Okay, 1 minute, Ellen Goodman.
Yes, the WI did some work on mental health problems in prison.
Yeah.
And I wonder if you could tell us something about the unmet needs that you found in that campaign that you ran, please.
Well, the unmet need really is to have a provision for the mentally ill out in the community before they actually become perpetrators of crime. It's not so much when they're inside, it's before they get in that we're worried about.
And the government has introduced a new, as it were, signposting diversion system,
yes, we understand.
Which everybody welcomes. But do you think the £5 million that they're spending on that is going to meet the needs which you observed in the work that you did?
No, I think it needs to be much more.
Why?
Because we need many more diversion schemes. The £5 million was only for 100 of them, and I think we need more.
Have you thought at all about the impact of privatising the health
Order. Just on the last question, and perhaps you could give an answer in writing. That would be extremely helpful. I do apologise if we have been somewhat abrupt, but we do have a limited amount of time. So thanks very much for coming along and for your evidence.